All right, welcome everyone to a presentation by Nabor on the 2025 Florida Realtors Florida Bar forms. We've got some new Bar contracts and a new condo rider to discuss today. Before we get started, I want to point out the Bar contract Florida Realtors legal hotline number is 407-438-1409. And if you have any questions on the Nabor contracts, you could be linked to a member of the Nabor Legal Resources Committee members at 239-597-1666 and let them know you have a question about the Nabor contract forms. My name is Erin Miller. I'm a real estate attorney here in Florida. I also serve on the Florida Realtors Florida Bar Joint Committee that revises the Bar contracts and addenda, and also have served on the Nabor Legal Resources Committee since 2020. Without further delay, let's go ahead and go through our agenda. Florida Realtors Florida Bar released a new version of the Bar contract on December 2024, December 31st, 2024, just before a new requirement came about for condos. We'll talk about those condo disclosure requirements. In particular, when the Bar contract, we're going to look at paragraphs 9, 19, and 15. We'll go through those in the Bar contract itself, and then we're going to recap the condo disclosures that are old news under Chapter 718, 503 of the Florida statutes. And we're also going to talk about the new disclosure requirements that are now in the Condo Rider A, so Bar A, condominium rider, that was also revised December 2024. So when you're looking at your Bar contracts, you always want to make sure you're looking at the footer of the contract to make sure you're using the most up-to-date version. So when it comes to the Florida Realtors Florida Bar contract, it's version 7. The most recent version before that was version 6XX. So version 7, and it was revised in December of 2024. Same with the Condo Rider. You're looking at CR-7, revised in December of 2024. And for the Condo Rider, we're going to look particularly at paragraphs 6 and 10. All right. Just a quick note about the Florida Realtors Florida Bar Joint Committee. It's a committee made of realtors and attorneys, one from each appellate district here in Florida. And they make up the contract subcommittee that revises every 2 years the Bar contract, unless there are outside influences, legal changes, lawsuits, for example, that require more frequent updates. Again, this version was finally released in December of 2024. It's for all transactions as of January 1st, 2025 and moving forward. So make sure if you've got a listing that has an old addendum uploaded into MLS that you're updating it to use the new form. And another quick note, the Florida Realtors forms are not necessarily Bar contract forms. So you make sure you look at the footer again, and it says approved by Florida Realtors Florida Bar. That is a Bar contract form, but know that Florida Realtors has released a number of other forms for your use, including listing agreements, buyer-broker agreements, disclosures, vacant land contracts, commercial contracts, those kinds of things. So just a quick note, Florida Realtors forms are by the Florida Realtors Forms Committee. Our Bar contracts are created by the Joint Realtor Attorney Committee. All right. We'll dive right into paragraph 19. There were 2 new checkboxes added for riders FF and GG, so you can attach rider FF and rider GG to your contract. And a quick note about incorporating those addenda to your contract. You want to make sure that you are checking the appropriate box and including them in your contract. So check the box, add the addendum, attach it to your contract, and make sure the buyer and seller both sign the addenda to effectively incorporate that into your transaction. Here I've got a snapshot of paragraph 19. You've got FF and GG. You've got those arrows pointed there. Rider FF is a credit related to buyer-broker compensation. Rider GG is a seller's agreement with respect to buyer-broker compensation. And we'll go through what each of those forms are really quick so you have a refresher. Just get Bar addenda. Check the box, attach it to your purchase contract. Rider FF, we know what that is. Rider GE, we know what that is. But note, we don't have checkboxes with respect to compensation agreements. So there is no checkbox. We'll go back. Well, there is no checkbox to attach a CASB, a compensation agreement from the seller to buyer's broker, or to attach a compensation agreement between a listing broker and a buyer's broker, and that is intentional. The idea is to make sure your sales contract executed between your seller and your buyer and all of the addenda that are attached to the contract are only executed by the seller and the buyer. Remember, those compensation agreements are executed by parties that are other than the seller and the buyer, whether it's a listing broker and a buyer's broker or the seller and the buyer's broker. So those compensation agreements should not be attached to your sales contract. If you need to use an addendum related to buyer broker compensation, I suggest we use Rider FF or Rider GG. And for more information regarding the NAR settlement and the forms that were released as a result of the settlement, you can go to floridarealtors.org/law-ethics and go to the NAR settlement certificate lawsuit link. There's plenty of information regarding each of the new forms and the dates that they were released and their purposes. Quick recap on Rider FF is a credit related to buyer broker compensation. On the form, you're going to make sure you add the buyer brokerage name, add the amount of the credit from the seller to the buyer. Again, the buyer is requesting a credit from the seller that would offset the buyer's cost at closing. So it's a credit from seller to buyer towards the payment of buyer broker compensation. If the credit exceeds the lender's allowance, you have an option to decide whether the balance is paid directly from the seller to the buyer broker or whether the credit is reduced. But Rider FF, as an addendum to your sales contract, it does not modify your buyer broker agreement. It does not modify your compensation agreement. This is just a means for the buyer to request a credit from the seller towards the payment of buyer broker compensation. Here's a snapshot of the form. So it's Rider FF. You've got to add the name of the buyer broker. You've got a percentage of the purchase price, a dollar amount, or a combo. And then, again, you've got to decide whether, if for some reason the lender doesn't allow this type of a credit, or if it exceeds the amount of a credit the lender allows, you have the opportunity to reduce the credit to the maximum amount that the lender will allow, or have the balance of the credit be paid by the seller directly to the buyer broker. So rewinding a little bit, you've already got a buyer broker agreement, right? You've toured the property with a buyer, you've had a buyer broker agreement in hand. Maybe you don't know at the time of submitting the offer whether the listing broker or the seller are offering any kind of compensation, but the buyer still wants to submit their offer and request a credit from the seller to the buyer at closing towards the payment of buyer broker compensation. Rider FF will allow you to do that. Just make sure you're attaching the rider to the contract and checking the box. Rider GG, it's called seller's agreement with respect to buyer's broker compensation. So alternatively, if the buyer wants to go ahead and submit the offer, let's say they have an idea that maybe someone else is willing to offset their obligation to pay buyer broker compensation, but they don't have a copy of the CASB or CABB. They don't have a copy of those compensation agreements. So the buyer is able to submit the offer to the contract, or with the contract, attach Rider GG, and define a contingency for a short period of time to allow the listing broker and the buyer's broker, or to allow the seller and the buyer's broker to enter into a satisfactory compensation agreement between the parties. So you're going to need to define the contingency, which parties are going to enter into that compensation agreement, and for how many days. And then if that outside compensation agreement, again, between parties other than the buyer and the seller, if that compensation agreement is not timely delivered to the buyer, then the buyer has the opportunity to terminate within 3 days and receive a return of their deposit. So we'll see what that form looks like. Again, Rider GG, seller's agreement with respect to buyer's broker compensation. This is a contingency upon the execution of an outside agreement between parties other than the buyer and the seller. So buyer submits an offer. They want to make sure that the listing broker actually does deliver that compensation agreement to the buyer's broker. They've got a contingency to allow that to happen. Again, we've got a default provision of 3 days after the effective date. Parties can always adjust that time period if needed. All right. Okay, the next change to the BARBAR contract is in paragraph 15A under buyer default. There used to be another sentence in paragraph 15A that required a listing broker to split any portion of retained deposits the listing broker was entitled to under the listing agreement if the buyer fails to close. That language has been removed, so that provision has been deleted, requiring the listing broker to split any of the retained deposits with a cooperating broker. However, a buyer's broker would still have whatever enforcement mechanism they had under their buyer-broker agreement to pursue compensation from the buyer in the event of a buyer default. But we're just removing that language, requiring the listing broker to split any of the deposit they may be entitled to with that buyer's broker. Okay. Paragraph 9 was revised regarding closing services. In lines 168 to 170, we now have a big, bold language that references Florida Statute 627 and 7711 with respect to closing services as separate and apart from the title insurance premium and title services. So we're defining it as defined in the statute and making it clear that each party will bear their own closing services fees, either payable to the closing agent or another provider, as each party may select. So the following paragraphs, sub I, Romanet numeral I, double I, triple I, Romanet, were all revised to remove the closing services fee language as separate and apart from title. So in line 172, the seller can select the closing agent and pay for the owner's title policy and charges, and the buyer will pay the premium for any lender's policy. But we know, no matter what, buyer and the seller would each be responsible for their own closing services fees to the extent that there are any in that transaction. Similarly, if the buyer selects closing agent, they'll pay for their own owner's policy and charges and premiums for whatever lender's title policy exists, and buyer and seller are each responsible for their own closing services fees. In 90 days, we practiced Miami-Dade and Broward. It's sort of a bifurcated process where the buyer designates the closing agent and pays for the owner's policy and the lender's title policy, but the seller may have some responsibility for paying for a title search, a tax search, and municipal lien search. So it's a bifurcated process, but Miami-Dade and Broward each have their own provisions. In any event, buyer and seller are each responsible for their own closing services fee. That is not an unfamiliar concept for those of us who practice in Southwest Florida using the NABOR contract, where the buyer shall pay for and provide their own documents. The seller shall pay for and provide their own documents. So, but now we have it clear in the FARBAR contract, paragraph 9, that each party is responsible for their own closing services. All right, we're moving on to the FARBAR Condo Rider A. In paragraph 6, we're going to do a quick recap of the required condo documents that are required to be delivered to a buyer under Chapter 718, 503, sub 2, subparagraph D. We have the Declaration of Condominium, and I put an asterisk here because it's the Declaration of Condominium and any amendments that have been recorded in the public records after that declaration. We've got the bylaws, the articles, rules and regulations, FAQ, frequently asked questions and answer sheet, the annual financial information, and I've highlighted in green here the budget because the budget was added as a requirement in October of 2024. So if you're not quite up to speed on condo sales, budget is now a required document under Chapter 718, 503 to be provided to the purchaser. Additionally, we've got the DBPR condo governance form that is required to be delivered to the buyer. Now, question, who is responsible to provide? Whose responsibility is it to get these condo documents to the purchaser? The statute says the buyer is entitled to receive. However, we clarified in the FARBAR Condo Rider under paragraph 6 that the seller shall, at seller's expense, provide the buyer with copies of the condo documents. So, seller's requirements under the contract to provide at seller's expense these current copies of the condo documents. And that makes sense because our seller is the best suited person to obtain this information from the property management company or from the association directly. And remember, we've added to this provision the governance form. Note about the governance form, it is a form that does not vary depending on the condo association. It is a generic form that was produced by DBPR and essentially lets the buyer know you're going to buy in a condo, there will be fees, and there will be rules that you'll have to abide by. So make sure you're including that condo governance form with the other documents that are required under 718, 503, including now the budget. I have this slide because, well, there's a lot of information that is required to be included in paragraph 10 regarding milestone inspections, structural integrity reserve studies, and turnover reports for turnover inspection after July 1st, 2023. The reason it's important to note this language is also the explanation for why the Condo Rider is pretty lengthy now. It has a lot of big, bold language because it needed to follow exactly the requirements in the statute. If you follow with me to the very bottom of the screen, the fine print, it says a contract that does not conform to the requirements of this paragraph is voidable at the option of the purchaser prior to closing. So you really want to make sure you're using the most up-to-date version of the FARBAR Condo Rider that was released in December of 2024 that includes these disclosure requirements. So essentially, we're breaking it down to two parts. One is, does the contract have the required disclosure information, and has the buyer received the required documents to the extent that the reports are completed and required? Okay, so also, if you have a condo listing on the FARBAR contract and you use the old form, go ahead and pull the new form and update it. Make sure you're using the new Condo Rider. There's some more information the seller is going to need to obtain from the association in order to provide those disclosures to the buyer and attach it to the contract to comply with the statute. But also, we've gone into a new year, so now's the time, of course, to update your new budget, your fees, any application information, association contact information. Now's the time to make those updates. Here's what it looks like on FARBAR Condo Rider A, paragraph 10. There are questions the seller is going to need to answer. Essentially, the questions are summed up in, is the association required to have a particular kind of inspection? And if yes, has the inspection been completed? Is it required? Is it completed? And if the answers to both of those questions are yes, then the buyer has a right to receive those documents, whatever report that the association is required to have and has completed. So these questions look a little bit different than what appear in the NABOR contract, but they all answer the same question. So paragraph 10A, sub 1, for example, we're saying the association is required to and has completed a milestone inspection. Or 10A, sub 2, is not required to have completed a milestone inspection report, period. Or 10A sub 3 is required to have completed the report, but has not completed the inspection. That disclosure language is now required by law, even if the seller knows that their particular association is not required to have any of these reports. They need to complete this information in the Condo Rider to be able to provide it to the purchaser so the buyer can review this information at the time of contract execution. I'm going to summarize. Paragraph 10 of the FARBAR Condo Rider, we added all this language that complies with the statute, and we're answering questions. Is it required? So is the association required to have this particular type of inspection? If the answer is yes, move on to the next question. Has the association completed the inspection? If the answer is yes, then you know that there's a document they're going to need to obtain to be able to provide to the purchaser. And the seller is going to be able to answer those questions in the affirmative. Okay? So, for example, a milestone inspection. Is the association required to have completed a milestone inspection report per Chapter 553-889? If yes, it is required, was the report completed? If yes, the milestone is completed, then the buyer has a right to receive the report. Statute requires the delivery to the buyer at least 3 days prior to contract execution, or failing which the buyer has a 3-day right of rescission upon receipt of that document and execution of the contract. And remember, our 3-day right of rescission does not include weekends or legal holidays. Okay, so if a milestone is required, was it completed? If it was completed, then deliver a copy of the document to the purchaser, and they will have a 3-day right of rescission upon receipt of that document. Again, this is in addition to the other right of rescission that the buyer has for the other 8 pieces of information. These are additional only if they apply, if it's required, and if it has been completed. We also have the question, is the association required to have completed a turnover inspection report for a turnover inspection performed after July 1st, 2023 under Chapter 718-301? Well, we know that that date, July 1st, 2023, is a hint that is for newer condos. We still have to ask the question, is it required? And if yes, required, was it completed? And if it was completed, then make sure you obtain a copy of the document to provide to the purchaser. Similarly, we've got the same question with respect to structural integrity reserve studies. So is the association required to have completed a structural integrity reserve study described in Chapter 718-103 and Chapter 718-112? If the answer is yes, was it completed? If yes, completed, then the buyer has a right to receive the document, receive a copy of the report, and buyer has a 3-day right of rescission. I'm pretty comfortable saying the buyer likely has a 3-day right of rescission because the odds of a buyer having received a copy of the structural integrity reserve study at least 3 days prior to contract execution is pretty low. So I'm pretty comfortable that the buyer will have a 3-day right rescission. Doesn't matter how I feel about it. However, we're going to look at paragraph 10D, and there's an option for the seller or the buyer to select whether they have actually received a current copy of the report at least 3 days prior to contract execution, not including Saturdays, Sundays, and legal holidays, prior to contract execution, or under paragraph D, sub 2, this agreement is voidable by buyer by delivering written notice of the buyer's intention to cancel within 3 days, excluding Saturdays, Sundays, and legal holidays after the execution of the contract and receipt by the buyer of whichever of these new documents is required and completed. So if all 3 documents, all 3 inspections are required and completed, then again, the buyer has a voidability right after execution of the contract for 3 days after receipt of the last of the required and completed documents. I'd like to point out a few resources that may be helpful when you're trying to understand these new condo requirements and understand sort of the makeup of the new condo rider. We've got Chapter 718-503. If you have a hard time sleeping tonight, click on the link and you can pull up the statute for sort of an explanation of the condo docs that are required under the old rules, plus the new rules to the extent that those documents or inspections were required and completed. Also, DDPR has released a number of great materials. I would check out first the condos.myfloridalicense.com with respect to inspections. It defines the different inspections, plus the difference between a milestone and a structural integrity reserve study, who has to have it completed, what are the requirements. It also has an FAQ page, so go to DDPR new website, condos.myfloridalicense.com, and check out those resources. They will be helpful for you and also for your customers. And then I also have a link here to the governance form. But if you need to Google the condo governance form, you just DDPR condo governance form, look at the 2021 version for the most up-to-date version of the governance form. Just save it to your desktop and just know that every buyer is entitled to receive not only the 7 pieces of information specific to that condo, but also the 8th piece of information is the condo governance form. For information regarding new forms that are released by Florida Realtors and Florida Bar, go to floridarealtors.org/tools/research for form updates. That is the best place to find the newly released forms and also explanations as to what those new forms are all about. And also, you can go to Nabor Realtor Tools. I'm not sure if you know this, but you can go to nabor.com/realtor-tools, Nabor contracts, where you can find the most up-to-date versions of the Nabor contracts. Also, you can find a complete list of all of the Nabor forms in the form library. And very soon, you'll have an update to a sort of a summary of the changes to the Nabor forms, and also the changes to the FAR Bar forms will be available in sort of an article format for you to reference. And if you have any questions, please feel free to give me a buzz, or you can contact Nabor Legal Resources or Florida Realtors Legal Hotline at your convenience. And good luck out there.